afternoon, everyone. So I will be speaking on key legal issues relating to bylaws. So just as a way of introduction, I have explained what local government constitutes. Everyone here, I believe most of us here, most of the people here are honorable, so I don't really have to explain what tier of government is a local government. But even if you are not a councillor, there is a saying that says family is the smallest unit of a society. And now I'm saying society is the smallest unit of every government, which is a local government. Your local government is your community. What you do at the local government affects your people directly, your community directly. So even if you are not an honorable, you are not a serving honorable, you should know that whatever you do directly affects your community. So I said local government constitutes the third tier of government in Nigeria and represents the level of government at the grassroots. So there is a constitutional provision for local government, and even that, there are still issues and problems because there is no, the law has not really expatiated on how the power should really be shared between the state and the government. Yes, there is a section of the law that provides that local government should do this, should do that. But if you look deeply, it still falls back on the state assemblies. They still make laws. So from there, in a way, it limits the power of a local government. So that's what I'm trying to explain, that there seems to be a problem. Yet, yes, there is a section of the Constitution that provides that local government should take responsibility of communities. But in a way, the federal government and the state government still affect the functionality of a local government. So what are the functions of a local government? When you look at your constitution, look at sections, I don't want to bore anybody with any law. Look at section 7 of the Constitutional Law of Nigeria 1999 as amended in 2024, yes, or 2025. So if you look at that law, it provides for the sections, that section gives power to the local government, it creates local government. And if you look at the fourth schedule of the Constitution, it states the functions of local government. There are some that are exclusive to the local government, and there are some that are shared between local government and the state government. For the exclusive ones, we have laws on birth, death certificates, birth certificates. We have making recommendations to state economic planning, collection of rates, radios, license, television license, and other. I don't want to bore us with the functions of that. Major thing we want to look at is the legal issues that we have with bylaws. In the discharge of the statutory responsibilities, local government council enacts bylaws. Bylaws simply means the law at the local government level. And these laws have been made by the people that are seated here today. So what are the legal issues we can have making those laws? I believe if we have the knowledge on the mistakes we can make that will affect those laws, we would do better in making laws. The first one I stated here is state financial and administrative interference. Like I mentioned earlier, that yes, we have a local government provisions in the law, but there is always interference from the state government because there is no explicit distinction between the local government and the state government in the constitution on how power should be shared. Yes, they have stated that these are the things local government should work on, but if you look at it in total, in fact, there was a time the state governors, they scrapped elections on local governments. What they do they were just appointing caretakers. And if you appoint a caretaker, will I not be answerable to the person that have appointed me? I will. In a way, to interfere with whatever I want to do. If as a councillor we have come up with, oh, this is what we want to do, and the person that has appointed the leader has said, no, we are not doing this. There's nothing you can do. So whatever law you make at that time, if anybody comes in and they look at the law and they say, oh, this is just like someone has just imposed this on us, then that law might not, at the end of the day, function well. Then also limited constitutional autonomy. Although recognized by constitution, local government operates under every state influence. It's still the same point, but in a way different. The constitutional power has given local governments some things to do, some functions to perform, yet they have not given them that power to really function. And any law, there's a section in the constitution that says that whatever law you make that is inconsistent with the constitution, not even state law, constitution, it is null and void. That means it is not even effective. Nothing at all will work on that particular law. So the same way, if you're making any law without the National Assembly, without it being consistent with the National Assembly laws, it will also be void. I think there is a case like that they mentioned that there was a law that was created, it was not, I think I mentioned the case. In this suit, there is a case, if I see it along the line, I will tell you. There was a law that was made that was interfering with the law of federal government, which was on tax. The judgment of the court was that because that law is inconsistent with the federal government's law, it is null and void. So those are the limitations we have by making bylaws at the local government level, especially when it is inconsistent with the national law and the state law. Then another one, this is a recent judicial intervention on local government funding, which is also when I was talking about separation between local government and the state government. I think there was a time when a local government wants to get money, they get it through states for government. They will have an account that they pay the money to and get the money. But recently there was a judgment in 2024 that says that there should be a separate account where the local government fund goes to. It doesn't make any sense that we need money, we have to come to the state account first to get the money. The money should come directly to us so that we can have our autonomy. Though this might just still be in paper. But let's just continue. Then another risk factor of a bylaw not functioning well is weak legislative powers and consistency with the higher laws. I have stated that earlier that if the law of the local government is inconsistent with the federal government law, constitution, and the state government law, it will not be effective. And that was the judgment in the case of Chevron Nigeria Limited versus Warri North Local Government Council. And the court emphasized that bylaws sit at the lowest rung of the legislative hierarchy and cannot supersede laws enacted by state house of assembly. In essence, what this law is saying is, no matter how intelligent that law may be, no matter how good that law may be, so in as much as it's not consistent with the superior laws, it is not effective. So if you as councillors, you've made your research, you've worked on one serious law like that and you've done it, and you feel like this is a good way to go, especially when it's coming from the society you are really familiar with. Maybe someone has brought this to your attention, you've passed it has passed through the normal stage, and you've enacted it. Why should they say that if it is inconsistent with that law? Because we are saying local government is the government of the grassroots. That means whatever relationship you have is cordial than that of the higher laws. So this, in a way, affects the effectiveness of bylaws because it will go to nothing, to go to even no issue. Then poor compliance with legislative process. We all know the meaning of legislative procedure. There is first reading, second reading. If you as councillors enact laws that you didn't follow that due process, and someone in the long run just say, no, this thing, you might have passed the law, it might have been a bylaw, and the person wants to contest it. This law did not pass through the proper procedure. It cannot be enforceable. The law will upheld it that it cannot be enforceable because it did not pass the proper procedure. They have a procedure a law should pass before it could be enacted. The same thing as National Assembly laws. They have a procedure they should pass. You cannot bypass that procedure and say, oh, you just want to enact it as law. So those are the legal issues you might have making laws if you have not done it in a proper way. Then lack of legal expertise. Yes, I know there is a provision of having legal departments at the local government level. But sometimes, even with that we are lawyers, you read some laws, you have to read it like 5 times, 10 times before you understand. Because most of the people that make that laws, they just made it out of probably they copied it from somewhere and dumped it on us. So we are trying to relate that law to our own, our society, our community. So you have to read it and read it before you understand. Now imagine if you are not even a legal expert, Imagine the laws the person would have written, the procedure you have gone through, and at the end of the day, you see that this thing is not even applicable here. So it is a serious issue. I feel like, or I know that lack of legal expertise can also make a law to be void. For example, there are some things that lawyer will know, or an expert. There are some fields that I am not an expert in. There are some fields that some persons are expert in. So it is better you go to those people that are expert in that field to get the first-hand knowledge to enable you to enact good laws. Then there is a case also in that law, in that section, that the local government, they sued the local government. I think it was Cross River. So they sued the local government. They just abandoned the case in court. They were not going, nothing. They told them at the local government that they filed the necessary things. At the end of the court gave judgment against local government. Local government now came back, oh no, it's not our lawyer, oh, we don't know the person, we don't know. No, the government says it's not our business. Even as a local government councillor or anybody, you should even follow your case as a party, not even as a lawyer. So the fact that you are telling that this person is not a legal expert, it's not our business, you have passed that stage. If it was as a proper stage that you are in court and you see that this person is not an expert, probably you would have changed him and get. So it is a very crucial part at the local government that should always try as much as possible to get experts in the legal department. And even if you don't have experts in the legal department, there is a room for you to get experts outside, just like consultants, that you can, oh, this is the issue we're having, how can you help, what's the way to go about it. The violation of natural justice, there's what we call natural justice. When you are considering some things, maybe sanctions, you're considering fines, it shouldn't be something that you just decide, you are the one that made the law. You still want to be the one that want to enforce it. You still want to be the one that want to sit over it. No matter how strong or how valid that law is, no matter how strong that law is, it is invalid. Because you cannot be a master in your own court. There is a section in section 36 of the Constitution that provides for fair hearing and justice generally. Then another thing is executive legislative conflicts. I think this is an in-house thing. It is me that I'm there. And I think it's normal to everybody. We are always quarreling. The legislative is quarreling with I have the best power. No, but if you see ourselves like just like a checks and balances, I'm not here to control you, you're not here to control me. Laws will be better. It will be better made, even for the interest of the citizens, and not just because we are in power. So frequent power struggles between local government chairpersons and legislative councils often stall governance and result in abuse of power, including unlawful suspension. So even if you make laws, sometimes the legislative can still come there, oh no, this did not do the proper thing. It is not as if it did not do the proper thing, because of the tussle of power between the legislative and the executives, there might be issue with that law. So it is always good to always try to balance the lack of public participation. The reason you are a councillor, or the reason you are where you are, is because of the citizens of Nigeria, because of the people in your community. The reason why you are elected there or even chosen as a caretaker is because of your community. So if you are making any laws that you are not considering the participation of the public, even if they are making laws at the national assemblies, there is a stage that they write to all the civic societies. We want to talk on this law, we want to work on this particular law. What are your observations, especially when they are doing the constitutional review? They write to, I am aware, they write to our NGO. These are what we are considering. What are your own opinions about it? Not talk of local government level, where we can even see ourselves to interact. Oh, we want to make law on chieftaincy. What do you think is the traditional rule in your society? How can we do better? If you have participation of the public, you have a better grasp of what they want and how the problem, because most laws are created to solve a problem. You will have the grasp of knowledge of the problem they have and how to solve the problem. So lack of participation is another crucial point in making held laws, like laws that will not be valid at the end of the day. Then judicial enforcement challenges. This one is a serious issue. There are some times that you've gone through the proper procedure, participation of the public, everybody has submitted whatever you've enforced the normal procedure, it has been assented by the executive. Now, there are some laws that you want to enforce. You cannot enforce it because they feel like it's local government now. Thank God for Lagos State. I think Lagos State is doing well. For every every bylaws that they have, all these penalties, offences, they have a special court for it. Consider other states that you have just normal courts that you go to and you file. Even the normal case that you file can be there 1 year, 2 years, 3 years, 4 years. How many years are you serving as a councillor? Your time must have even elapsed before the judicial judgment on that. But thank God for Lagos State, I'm aware they have different sections. They have mobile courts for if you violate the what do they call it now? If you violate any laws, any local government laws, they can easily sue you at that law and it will be enforced easily. So enforcement capacity and encouraging local government authorities often lack the power because there's not enough training, integrity required for effective enforcement. And sometimes too, when you get judgment against someone or someone gets a judgment against local government, for example, you sacked one of your staff which is done wrongfully. How do we enforce judgment against local governments? It's a serious issue. Even let's look at, you've gotten judgment against police officer. To enforce is always a problem. They will tell you cannot garnish state government account. You have to go through CBN. You must get approval from another sector in state government. If you are the one in that state government, we will give the approval. Although we are contesting that, and I'm sure we'll come out with a good result. So enforcing judgment against local government or local government enforcing against individual is always not easy. For example, you saw someone that crossed the road, you want to arrest the person. How do you prove that the person really crossed the road? No pictures, nothing. How will you prove that in court? Then revenue collection disputes. This one is just a general one. Illegal, arbitrary, or excessive levies. If government has levied, federal government has levied someone on a particular tax, because this Nigeria, you can pay 10 tax, double tax on one single thing. State government is levying the person. Local government too want to levy. It's a problem. So if you make any laws without considering the initial laws that are enacting, any law that you're imposing tax, revenues, without considering the previous laws, it is also a problem, because by the end of the day, you want to enforce that law, you cannot enforce it. Because there is a law, maybe the person is paying council money here, is paying the same, they will just refine it. They might say this one is public toilet money, this one is television. They will not want to tell you television money. They will come to your office, they know that you have television. They still want you to execute it. So if you have revenue connection is a serious issue at the local government. They want to collect, especially this Lagos State. They want to collect, they want to tax you on every fact. If they can tax you on your bread, they will tax you on that. So it's a serious issue for Lagos. Yes, I live in Lagos.
Okay, no, here is not Lagos.
Yes, I know this is not Lagos. But the councillors were speaking to their own Lagosians. So what are the limitations of actions against, this is where, this one is actually good for local government. You can't sue local government without giving them pre-action notice. And the essence of this pre-action notice is not that, oh, I cannot sue you, no. The essence is that they are giving you time to see, oh, can we reconcile with the person? Why is this person suing local government? But most of these local government lawmakers or executives, they don't even look at it. They might even collect it and just dump it somewhere. But that's why we said, when you have experts, what you're supposed to do is immediately transfer it to the legal department. The legal department will look at it. How can we solve this problem without even going to court? Is there a way we can mediate between our local government and the person suing us? That is the essence of that 21. Is it 6 months? Yes, 6 months reaction notice. They cannot sue. If they sue you, you can file a preliminary objection that no, I cannot because we are not served the adequate notice. Then failure to comply renders the action incompetent and void ab initio. That means you cannot sue. That's the essence of that whole grammar. The Supreme Court in Etiosa local government versus Jegede and another held that the purpose of pre-action notice is to encourage negotiation and amicable resolution before litigation, just to avoid excessive money. So then also there is a limited number of months in which you can sue local government. If I'm not mistaken, I think it is 8 months. If there's 8 months from when the action occurred, like if you think local government has heard you or they've wronged you in any way, you think I won't take any legal action, you must sue local government between that time of commissioning of that offence and 8 months. Anything 8 months 1 day, you cannot sue them again. And that one, unlike this pre-action notice that if you file in court, than you've not served them pre-action notice. They will tell you, okay, you can still leave it, withdraw the matter, go and serve them pre-action notice, and when that timeline lasts, you can come back to court. But this one, if it is over 8 months, it's limitation of time. You can never sue them again, and that's the end of that matter. So conclusively, if the factors discussed are carefully considered, if before you make any bylaws, you think of what is the implication of me not considering these factors, like public participation, like expertise, knowledge in making the laws, like seeing, oh, is there any other existing law aside from this particular law? Or you look at, is this law inconsistent with the federal law or the National Assembly laws? You will end up just wasting time, wasting resources in making that law, because at the end of the day, the law will be void ab initio. Thank you for listening. So I think I'm taking back my role from here. The next.
Who was timing you?
Nobody timed me. But at least I maintain my time.
No, questions. People have questions.
No, we'll ask questions later. Let's just take the last section before we go to question time. I'm sorry, please, sir.
Barrister.
Sir? So we'll call on Mr. Ayotunde to read the profile of the next speaker. Thank you, sir.